Welcome to Our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the American Bar Association's Antitrust Law section. My name is Alicia Downey, and the title of today's episode is Who is Michal Halperin? Meet the former Director General of the Israeli Competition Authority. Michal Halperin is one of 4 current and former competition agency heads, all women, who were featured panelists at the Antitrust Law Section's annual spring meeting in Washington, D.C. in March 2022. There simply wasn't enough time to do these inspiring panelists justice, so by popular demand, we are dedicating an episode of Our Curious Amalgam to each of them. In this episode, we'll ask former Director General Halperin to give us a brief overview of Israel's competition regime and tell us about some of the Israeli Competition Authority's most newsworthy accomplishments under her leadership and how her agency became a key player in recent economic reforms in Israel. We'll also find out a little bit about her own professional journey to the top. Joining me today is my co-host, Elyse Dorsey. Hello, Elyse.
Hey, Alicia.
Elyse, would you like to introduce our guest?
I would love to. Michal Halperin is a graduate of the law faculty of the Hebrew University in Jerusalem. From 2016 to 2021, she served as the Director General of the Israeli Competition Authority, where she led the Competition Authority's criminal prosecution and administrative enforcement proceedings in landmark cases against cartels and dominant entities such as the elevator companies, the natural gas monopoly, and Facebook. Before being appointed Director General of the Competition Authority, she was in private practice, leading the competition and antitrust group at the firm of Mader Law. Earlier in her career, she was the chief legal advisor at the Israel Competition Authority, where she headed a team of 25 legal professionals. Michal is currently a senior fellow at the Mossavar-Rahmani Center for Business and Government at the Harvard Kennedy School. Welcome to Our Curious Amalgam, Michal.
Thank you, and thank you for having me.
Yes, we're delighted to have you here, as Alicia said. So we thought to kick things off, a good starting point would be for you to describe to us what's the overall structure of Israel's competition regime, and maybe you could use the U.S. or the EU as a reference point for us.
Yeah, it's a big question to start with, but let's kick off. Israel is a very special blend of both European and American influence, but let me go one step back and say that very much like other regimes of competition, Israel competition regime deals with restrictive arrangements, cartels and other arrangements, with controlling of monopoly power, and with merger control. So these are always the 3 main issues that every agency deals with, and so does the Israeli Competition Agency and the Israeli competition regime. Why influence of America and Europe, both of them? Because like the US, in Israel we prosecute cartels criminally. We are one of the few countries in which cartels is a criminal offense, and the Israeli Competition Authority has a record of prosecuting cartels and indicting cartels and reaching convictions and even putting quite a few executives in jail for their involvement in cartel and in bid rigging. So that's very much like the American regime as we know it. But when it comes to monopolies, here we see much more European influence. In fact, all the provision of the Israeli law of abuse of monopoly power is a cut and paste of the European Article 102 of the European Treaty. So when it comes to enforcing antitrust law on monopolies, we very much interpret the law according to what is the case law in Europe and what is done in Europe. So that's where we get the European influence. In merger, we have an ex ante regime, which means that every transaction that meets the threshold that require approval cannot be closed until they receive the approval of the competition authority. But once they do receive the approval of the competition authority, then the transaction is per se legal, unlike what we know of from the US. So that's the whole big picture of how our regime looks like.
Great. And could you maybe tell us a little bit about the history and the organization of the competition authority? So, you started telling us about some of the agency's responsibilities and enforcement, merger review, and guidance.
Yeah, so the Israeli Competition Authority was established in the mid-90s. It was established as a professional agency and an independent agency. It has its own budget and its own authority to hire employees, and therefore there is no political influence over it. So it's pretty independent, and it was able to create itself a reputation of a professional agency, agile agency. It has today approximately 120 employees, and they deal with criminal prosecutions of cartels. They deal with merger review, and that's what they've been doing since the 90s. And the competition agency evolved in a very unique way, because it started from criminal enforcement at merger review, and only after that they started to create a more complicated case laws dealing with vertical arrangement and guidelines on more complicated transactions. And administrative enforcement, administrative fines were introduced only about a decade ago. So that's pretty new to the competition agency. So peculiarly enough, criminal enforcement was way before we had administrative sanctions. And very recently, a few years ago, we started to create the advocacy arm of the agency, which I would probably talk a lot about.
Excellent. And were there any, unique aspects of the authority or unique competition issues in Israel that you experienced?
Yes, of course there are. First of all, Israel is a small economy. And when you have a small economy, you can only maintain in many industries a few competitors. There is in many industries there is no justification to have multiple players. So there are many industries in which the competition agency deals with very few competitors. So that's, first of all, we're small. And the other thing is that we are kind of what we call island economy. We have very little commerce relations with our neighboring countries. So the Israeli economy is relying on import from far. And this puts a lot of emphasis on the need to keep import open and easy. And that's a very unique issue to Israel and to how we look at things from competition point of view. And the third thing is that might, sound strange to an American ear. The Israeli economy originally was a socialistic economy. Until the mid-80s, it was an economy that was owned and administered mainly by the government. And it started to shift to a market economy only in the 80s. Now, today we're almost 4 decades after that, but we are still in many aspects in the transition to market economy. So we look at Israel as a market economy, but in fact there are things that we have in our in the structure of our commercial lives that are very much left over from the socialistic regime. So, for example, in many infrastructure areas, we would have monopolies that were previously owned by the government or are still owned by the government. The electricity company is owned by the government. The telecommunication company was privatized, but is still a monopoly. We have only one airline. We have many other infrastructures like ports that are owned by the government. And this also influences the way that we analyze competition issues and the issues that we need to deal with.
That is very interesting, and yes, very different from the United States. This is now a chance for you to brag a little bit. What are some of the newsworthy accomplishments of the agency while it was under your leadership? Big cases, big reports?
Yeah, time to brag. So that's a part I like. No, but really, seriously talking, the period that I was in the competition authority was really a period of transformation. We made a lot of reforms, a lot of changes, a lot of shifts. It was a marvelous period. We changed the priorities of the competition authorities. We went through quite a few reforms. We were able to convince the legislator in Israel to go with us and several reforms that we wanted to promote. We changed the internal structure of the competition authority. We even changed the name of the competition authorities. It was called the Antitrust Authority, and now it's called the Competition Authority. And we were able to reach a peak in enforcement, both in criminal enforcement, where we were able to convince court to raise the bar of punishment on executive and to send them to long-term prisons for prison time for cartel offenses. And both we were able to establish administrative enforcement through administrative fines against monopolies, things that was not done before. So it's really a period of transformation and great achievements. But the two things that I want to mention that I'm most proud about is, the first one is the reform that we've made in the competition law, which was a very substantial reform in which we try to reduce the bureaucratic burden on businesses on the one hand and strengthen the enforcement abilities of the competition agency on the other hand. So until that time, many arrangements needed to go through an ex ante approval by the competition agency, and we introduced a kind of a self-assessment regime where very much like what was done in Europe 20 years ago, where we allow businesses to self-assess their arrangement instead of coming to get the competition agency's approval. So that was the reduction in bureaucracy and a reduction in burden. On the other hand, we were able to strengthen the authority enforcement power. We raised the bar for administrative fines. We introduced the monopoly, the definition of monopolies that is not based only on market share, but also on market power, which was very important for us. And we made quite substantial changes, and this was a huge step for the competition law in Israel. So this is one thing that I'm very proud about. The other thing that I'm very proud about is a change we did about advocacy. I understood very quickly that we can make a lot of progress in competition in many cases if we reduce regulation or reduce the limitation that the government puts on competition in many industries. So in many cases, the cause for the incompetitiveness of markets is the government itself, or the restrictions that the government imposes, or the way that the market is structured. And if you can find the reason for that and advocate for a more competitive policy, then you can create a very effective and quick improvement in competition. So we started getting involved with other governmental agencies in promoting competition and advocating for more competition. We created an advocacy branch within the competition authority. We educated ourselves on skills on how to do advocacy, which is very different than enforcement. I mean, it's totally different skills. And we started to put a lot of resources and time into advocacy work, and we measured ourselves and our successes in advocacy. And I think today the competition authority is involved in every major economic issue that happens in Israel, whether it's a privatization process or whether it's a bid to a big bid on infrastructure, or whether it's a licensing for new competitors. In many issues, the Israeli Competition Authority is now involved in the creation of processes, economic processes and economic reforms, and that's a huge step forward.
Well, as the agency expanded its role into so many facets of the government, was there opposition? Were there challenges made to those sorts of initiatives?
Everything we did in the Competition Authority and advocacy, we did voluntarily and without really having an authority on this. So we cannot impose our recommendations. We can only bring data, bring our research, bring our conclusions, and try to convince other governmental agencies that it will be good and wise to promote competition in their area. And that's why I was saying that it's very different skills than being an enforcer. Because when you're an enforcer, then you need to listen, you need to be able to hear the arguments, you need to be able to decide and to decide correctly. But at the end of the day, you are the one making the decision and it's up to you. When you are doing advocacy, you need to be convincing. You need to convince others. And also, you need to be willing to do some compromises. So there are always contradicting interests that needs to be balanced. And you do not get out of the room with everything you wanted. You need to understand that other interests also are coming into the table and need to be balanced. So these are unique things that goes with advocacy, and we really needed to educate our team how to do that. We put a lot of resources to it, and I think we achieved quite a lot.
So the power of persuasion.
Yeah, so you were speaking about the power of persuasion and convincing folks. Have you found that to be a challenge? I think we want to ask, what's the public perception of competition regulation in Israel? And is there a sense, as some people here in the US feel, that big companies are really too big and mergers should be more strictly controlled?
Competition agencies are a very unique regulator, because on the one hand, they are perceived as a regulator. So they tell you if you are allowed to merge. They publish all kinds of guidelines on how you're supposed to do your businesses. So on this aspect, they are like many other regulators that put some limitations and boundaries on how you're able to do your business. On the other hand, there are regulators that promote free market and they oppose regulation. And they advocate for reducing limitation as possible. So it's kind of a peculiar position to be in. And that's why when I came to an audience and I came to the point where I had to explain why big is not necessarily bad, that's usually when I lost my audience. It's very difficult to explain to the public why big is not necessarily bad, and because you are there to eliminate or to prevent companies to become big, right? So when they become big, why do you not do anything about it? Why don't you prevent them from becoming big? This is something I was struggling with quite a lot. It's a complex thing to explain, and I'm not sure I'm not sure I succeeded at all. So the short answer to your question is yes, the public perception is that big companies are too big and need to be smaller, and that big is not good, always not good.
Some of our enforcers have been in the same situation as you, so you have something in common. I want to turn now to talk a little bit about your professional journey. This was something of the focus of the luncheon, in which you were one of the panelists that I talked about at the top of the show. Going back to the very beginning, what interested you in a career in competition law?
Well, when I was a law student, there wasn't any antitrust law in Israel. Needless to say, there was no antitrust course in my university. I don't think there was any professor that was an expert in antitrust. I don't think anyone knew anything about antitrust. The law was enacted in 1988. It took a while until it picked up. And when I went out of law school, I didn't know that this is an area of law. And the first time that I was giving a question on antitrust and I had to open the law and read it, it seemed such a blend of words that are unreasonable and unexplained. It really didn't make any sense. I have to tell you, the first time I saw this law, and usually you read the law, you understand it, but this was new to me. But when I started to go into it, I was fascinated. And I still think that antitrust law is one of the best areas of law that we have. And this is mainly because it's so analytical and because it's based on economic reasoning. So when you go into it, the issues are absolutely fascinating. And I think that everyone who practices antitrust law is really lucky. He gets to deal with the best issues.
Well, we feel the same way, don't we, Elyse?
Yes, absolutely. We love it here.
That's great. One of the focuses of the panel was how you all, as women, made your way through what's sometimes an unwelcoming profession, how you made your way, in fact, all the way to the top in some of important government agencies. Were there times that you felt that being a woman gave you a particular advantage as you went along?
I really don't think that being a woman was ever an advantage. The more important question is whether it was a disadvantage. And here the answer is a little bit more complex, because when I was going on and doing my things wherever they were, I never felt any bias towards me. Of course, I never felt any discrimination, and I was not aware of anything wrong. It usually only when I looked on things from retrospect, I thought that I understood that there were things that were maybe biased. So, for example, I believe today what I didn't feel in real time, that media criticism is more aggressive towards women than towards men, not because of any intention, but because of a very basic bias of how we are. So, but these are things that are usually looked at in retrospect and not in real time.
Oh, that's interesting. Israel has a history of women in strong leadership positions. Do you feel that there's something like that that maybe makes the environment there more amenable to women leaders like yourself?
Well, I have to say that I do not share the feeling that women are doing better in Israel than in other countries. We did have many years ago a woman prime minister, but generally speaking, I think Israel is way behind in its acknowledgement of the need to create diversity. Diversity by many aspects, but also by gender aspect. I think that there is no understanding to this issue, or not enough attention to this issue, and I think that there's a lot of work to be done there.
That's true here as well in the United States. But now turning to what you've been doing since you stepped down, you left the position of Director General when was that?
Well, and I was at my position until last July.
Ah, okay. And so what have you been up to?
So I've been here in the Harvard Kennedy School. I'm a senior fellow here, and I am doing a writing and researching on different topics that relate to competition. So I'm writing on competition in publicly financed healthcare sectors, especially looking at the Israeli model, whether this is a good model to copy as a administered competition in healthcare sector. And also I look at how agencies deal with big tech. I think there is a common challenge among competition agencies that need to deal with big tech. These are really unique topics, new topics, novel issues that needs to be tackled. I hope soon to publish a paper that advocates for convergence between the American and the European competitive regulation of big tech, because I think the issues are common and it's a good timing and good opportunity to create such convergence. And there's a lot to achieve from such convergence.
Well, we'll look forward to reading that paper when it comes out. Good luck getting it done. Now we're going to turn to the part of every episode where we get to know our guests a little bit better as people. The first question we like to ask is to tell us something interesting about yourself that's outside of your professional life.
When I was a law student in Jerusalem, I worked in a very tiny restaurant in Jerusalem. And one afternoon, when the restaurant was quite empty and I was the only one in, I was robbed with knife by two people that came in and took everything from the cashier.
Oh no!
So this is something that I usually do not tell, but outside from my professional life.
Wow, that's not just interesting, it's traumatic.
No, it wasn't too traumatic.
Well, good. Then we'll now turn to the final segment of our show. It's a little game we like to play called The Curious Hat.
And now it's time for The Curious Hat!
The rules of the game could not be simpler. You simply need to pick a number between 1 and 10, and I will read you a surprise question corresponding to that number.
Okay, let's pick 4.
Okay, question number 4. What is your favorite sport and why?
Okay, so until very recently, my favorite sport was running. And the reason was that it clears your head. It gives you time to digest a lot of things that are going on during the day and you don't have time to think about. But when you're running outside and you have the quiet to run by yourself, you suddenly have time to think and digest it. So I love the running outside in nature and thinking things over while I'm doing so. Recently I started yoga and I love it a lot because it's a whole new thing with new skills and an opportunity to explore things that I haven't done in the past. So it's really nice.
Oh, well, that's very nice to hear. Michal, it's been wonderful having you on the program. Thank you so much for speaking with us today.
Thank you. Thank you for having me.
Join us next week for another episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.